Whenever you're ready, Attorney Pattis.
So I'm making a motion in the alternative for a directed verdict or a motion to dismiss. And I guess I'll start with the directed verdict. There are three grounds, Judge, for these motions. First is a lack of standing. Second, because of the misapplication of CUTPA, in this case, or an attempt to evoke CUTPA where CUTPA doesn't lie. Second, the failure to plead a necessary element in the complaint of ascertainable loss. And third, the presentation of the failure to present evidence that would support the verdict. And I make these motions in the face of and acknowledging the power of the default and with knowledge of the prior motion to strike, because our appellate courts have held that with respect to standing, that can be raised at any time, even in the presence of a default. That the appellate standard for review of a verdict in a CUTPA claim, even in the presence of a default, is de novo, and that suggests to me the trial court has the responsibility to evaluate purely legal claims at the close of the plaintiff's evidence. The evidence as presented in the representations of counsel thus far have been that they are seeking, with respect to the common law claims, only emotional distress. And that's all they're seeking. If you look at the manner in which the complaint was pled, Judge, the CUTPA claim is the fourth of the last of the viable counts. The negligent infliction count was withdrawn at some point. And that incorporates by reference the various pleadings that preceded it in the complaint. So, for example, in the common law complaints at paragraph 419, 432, and 446, the plaintiffs pled actual and substantial damages. And that's what they've reincorporated into the CUTPA count. Our Supreme Court is clear that emotional distress alone is insufficient to support a CUTPA claim. And I rely on Parnoff versus Aquarian Water Company at 188 Connecticut, Con-App 153, a 2019 decision, as well as DiTeresi versus Stanford Health 149 Con-App 502 2014. So the first motion is that as presented, there simply is insufficient evidence for.
Can I ask you a question, Attorney Pattis?
Yes.
So the CUTPA count incorporates the prior paragraphs which claim the emotional distress, but then the last paragraph adds the claim of damage. It's not limited to emotional distress. What say you about that?
The representations of counsel is they're seeking solely emotional distress here. There is no claim for economic damages, and thus the case as presented is going to be presented to the jury as a pure emotional distress claim, and that's insufficient as a matter of law for CUTPA. That's my claim. The ascertainable economic loss, the second claim, is as pleaded. And again, the appellate court takes a look at the pleadings to determine, even in the case of a default, whether it's adequately pled. Under Ritchie versus Main Street at 110 Con-App 209, we conduct a plenary review of the pleadings to determine whether they are sufficient to establish a cause of action upon default. It is our contention that they are not, because what the plaintiffs claimed was actual and emotional loss without ever claiming actual and substantial damages without ever pleading ascertainable loss. And I'm not trying to impose a magic word test on the pleadings. I understand that the plaintiffs are entitled to every reasonable inference, especially in the context of a motion for a directed verdict. But it's our contention that they've abandoned their responsibility to show ascertainable economic loss. Most substantially, though, we claim that this is a novel application and, frankly, a terrifying application of CUTPA, because this is an instance in which there is no representation whatsoever that the plaintiffs were harmed in any respect by Mr. Jones's commercial activities with respect to the sale of dietary supplements. So with respect to Soto v. Bushmaster, which the plaintiffs may claim opens the door, in Soto, unscrupulous advertising was used to sell military-grade weapons to a civilian. And the courts ultimately concluded that that was sufficient to support a CUTPA claim, even in the absence of a commercial relationship, because those unscrupulous ads placed into the hands of Adam Lanza a weapon that he used to slaughter people. There's nothing analogous to that in this case. Mr. Jones didn't oversell hair growth or follicle material or iodine to anyone. There's no evidence that anyone was harmed by his commercial activity. The court and the jury may conclude that Mr. Jones's speech acts were odious, and that's what defamation and defamation per se addresses. They may conclude that his speech inspired others to harass and intimidate these people, and I presume that falls under the intentional infliction of emotional distress. They may conclude that his verbal and written activities placed these plaintiffs in false light to their economic harm and detriment, but nothing in that speech or the consequences of that speech addresses what CUTPA is intended to address, or what Soto v. Bushmaster addressed, and that is whether consumers were harmed by the commercial activity affecting trade or commerce. If someone had gone out and bought a gross of these pills and thrown them at someone and hurt them, that might be an argument, assuming the ad encouraged people to do that. But what we have here is a novel attempt to use CUTPA to silence unpopular speech, and the purpose is plain. The purpose was announced in opening statements, which I realize is not evidence, but this is legal argument. The purpose of this litigation is to silence Alex Jones, and the only way they're going to be able to do that is with an enormous punitive damage award, which this court has discretion to award under CUTPA. The punitive damages will be limited in the common law claims to attorney's fees, and I'm sure they'll be significant, but they won't be significant enough to cripple Mr. Jones. So we think that CUTPA is being used for inappropriate grounds, and that the plaintiffs lack standing to bring the action because they cannot establish that they were harmed by Mr. Jones's commercial activity. As I understand the plaintiff's case, there's a strong and a weak CUTPA claim implicit within it. The strong claim is that they pay attention by way of Google Analytics and other analytics to spikes within their web traffic. Thus, when Mr. Jones speaks about Sandy Hook, it spikes. Let's talk more about it because it'll drive people to our site. The weaker claim is that by peddling fear, Mr. Jones is able to capitalize on that fear and inspire people to buy products. That might be an unscrupulous ad if a person affected by those products could come forward and say, I would never have bought it had I not been inspired by his fear. But that's not the claim here. What we have are three torts that will go to the jury, and my motion is not directed to those torts, Judge. I will concede that the evidence, if credited, is sufficient to warrant a judgment against Jones. As to the CUTPA claim, there's no case that supports what the plaintiffs intend to do in this case, and that is use a statute that is designed to protect consumers against unscrupulous trade and commercial practices to attack speech. And that makes this case terrifying from a free speech perspective, and we urge the court to strike this claim or to grant our motion, because nothing in our law supports an application of CUTPA on the facts as pled and proven in this case.
Thank you.